Hi, I'm Kathy Sandweiss at Jaburg and Wilk. I'm an appellate lawyer here. Congratulations on winning, first of all, but if your opponent appeals, you are going to have to defend the judgment. By defending the judgment, what we're talking about is we need to tell the Court of Appeals that your trial judge didn't make any reversible errors. The process as the appellee is simpler. It basically involves only one brief as opposed to the two briefs that the appellant would have to file. So there would be an answering brief that's based completely on the record that was presented to the trial court. And at that point, we're telling the Court of Appeals that based upon the evidence presented, the fact finder, either the jury or the trial judge, did not make any errors, and that based upon the legal issues presented, the trial judge made no legal errors. And that's very important because we're looking at what's the standard of review on appeal. If it's a legal error that the appellant is urging, then it will be reviewed de novo. If there's a factual error alleged, then the Court of Appeals will defer to the fact finder, which would be either the trial judge if it was a bench trial or a summary judgment motion, or it would be the jury. In that case, you've got a much better chance of it being affirmed on appeal. There's a big difference between lawyer mistake and trial court mistake, and a big difference between lawyer malpractice and an appeal. Clients are always coming to me and saying, I told my lawyer he should look for these financial records, and he never did, and he never presented them. And clients will say, I told my lawyer we had a fraud case, but he never raised that issue in the trial court, so can we appeal this? And what I am telling you is that's not an appeal, unfortunately. An appeal is based solely on the record that was presented to the trial court. If we don't have that evidence in the record, we're not going to be able to present it to the Court of Appeals. What the appellate courts say is that they want the trial court to correct its own errors first. Therefore, if an error hasn't been presented to the trial court, it's not going to be presented to the Court of Appeals. The Court of Appeals can't reverse it. What we're looking for is an error by the judge. I know it sounds kind of funny, we're looking for judge-made errors, but that's what an appeal is. We're looking at a three-judge panel, a higher court, reviewing what one judge did in the lower court.